Our final speaker is Steve Komarec, and he will be giving a case review of Supreme Court cases dealing with intellectual property.
All right, thank you, Katie. Thank you all for staying here to the end. I think I should have Austin pinch hit for me. He delivered Matt's speech probably better than I'll give my own here. So as Katie said, I will be giving a rundown of the Supreme Court cases that relate to IP in the last year, and there are quite a few of them, so I will be going fast. So the number of cases that they've heard in the last year does give rise to an interesting question. I think that why is there such a large number of intellectual property cases being heard at the Supreme Court? This quote here is kind of hard to read, but it essentially says that 20 years ago, IP cases were 2% of the Supreme Court's docket, and 10 years ago it was 4%, and in 2010 and 11 it was 6 and 5%, and at the time this was written at the end of 2012 it was 8%. The article that this was taken from puts forth the question that maybe it relates to the new economy, and I will talk about that in a minute. But the cases that I'm going to talk about are the Myriad Genetics case, which was just decided yesterday. That's probably the most high-profile one that you all have heard of. The other 4 cases that they've given an opinion on in the last 6 months are these. They relate to various topics: copyright, patent, trademark. So I'll try to hit at least the first 2 in a little bit of detail and then go through the second 2 quickly. The Supreme Court kind of rearranged how I need to talk about these given yesterday's decision. And finally, the Supreme Court isn't done. Don't worry, I'm not going to talk about these cases as well, but I will mention them at the end. So what do all these cases have to do with each other than being heard at the Supreme Court and relating to intellectual property? Well, nothing really, but I tried to ask some questions here in a framework that can that you all can think about of why is the Supreme Court hearing so many IP cases these days as opposed to 10 or 20 years ago. And I don't have answers to these questions, but I think it does 2 things that jump out at me in shifting from an old economy to a new economy as opposed to thinking from manufacturing to service economy. I do think there kind of is a new economy of acquiring and asserting IP rights more or less as a means to an end to generate revenue, whether or not you are a producer or not. And the second issue that I think it comes into play with these cases that I'm going to talk about are who the defendant is, who is the infringer. Is it a customer? Is it an individual? And what happens to those individuals? Does that have ramifications for the population, a larger segment of the political population? So that being said, we'll go to the first case, which does not relate to patent exhaustion, but that is a result of reshuffling from yesterday's decision. The Myriad case, as I mentioned, deals with patenting of human DNA, and in 2 forms. Now the history of the case is much longer than the Supreme Court decision. I think it bounced back and forth between the district court and the federal circuit in view of the other Supreme Court decisions, and they analyzed method claims and the system claims, or the process of what you're doing with the DNA as after you get it out or how you get it out. But the Supreme Court limited its decision to just the DNA that's been extracted in 2 forms. And the decision was unanimous or nearly unanimous. Scalia had the lone concurring opinion. It was about a paragraph long, in which he concurred with the holding of the court, except the bit about the biotechnology and the specifics of the DNA. He said he could not render an opinion because he has not an expert in that area. So, okay, so just to cut to the short of it here, the naturally occurring DNA segment was found to not be patentable, while the synthetic cDNA was found to be patentable. The naturally occurring DNA, it's kind of a circular argument, exists in nature in the same form as it does after it's been extracted. So therefore it's not patentable. The cDNA, on the other hand, is synthetically generated in the lab. It requires the lab technicians to actually do things. And furthermore, the DNA, once it's been made, is not in the same state as it exists in the human body. I guess as it's made, it only has half or a portion of the DNA, which is why it's called complementary. So it therefore does not, or it therefore is new and patentable. A couple of quotes here that illuminate the court's thinking. They were very attached to the idea that all Myriad did was discover or uncover something that was already there. They didn't come up with anything new. They just put forth the effort to find what already existed in nature. Even though they exerted a great amount of energy and effort to uncover and identify those genes, that alone isn't enough to rise to the level of patentable subject matter. I don't think these quotes here aren't based on new reasoning. They're fairly old principles in patent law, just kind of updated for the DNA context. And a couple other notes regarding drafting of patent applications. The court's opinion was very much fixated on the use of language in the detailed description of the patentee, saying it is a discovery of the present invention. They reiterated several times that the invention is a discovery, and they went on to talk about how the discovery was an iterative process, which, as I mentioned in the last slide, just merely discovering or uncovering something is not patentable. So I think the takeaway there is, as someone who's been in the patent drafting business for a while now, you hear various people say never use the word invention. I think this is a pretty clear case where that came back to haunt them. On the claim drafting side, the court talked about how the claims were specifically directed to the genetic sequence in the gene, and that that is what Myriad was seeking to try to protect, because that's what business they're in. The court talked about if they had directed claims to specific chemical compositions of a particular molecule, they could have maybe gotten a patent on that, but of course that would have been of less interest to Myriad. And I guess if you can understand what the difference between the chemical composition and claiming the genetic sequence, you're probably far better off than Justice Scalia, and you understand much more than I do about DNA. Okay, so that's about as much as I could figure out on that case in the last 24 hours. So the next case I will talk about is the Monsanto case, which is patent exhaustion. And this is another high-profile case where I think Monsanto's been in the news a lot lately, but I don't know if that's so much directly as a result of this case and the fact that they patented genetically modified seeds, but I think it's more there's a certain negative perception of genetically modified seeds in the population where they might not be good for the planet or safe for human consumption. But nonetheless, that's the environment in which they're operating under. So if you don't know, they make seeds that are resistant to their herbicide Roundup. So if you plant your seed, you can kill all the weeds, but the seed will survive. They sell the seeds under license, which allows you to plant the seed for one season only, and then requires you to sell the seed only to someone who is going to use it to produce food for consumption for animals or humans. So I think in order to understand this case, you have to understand what exhaustion is. So in the normal context, you would think you buy something. If you buy a bean, you can eat it, you could resell it, you could destroy it, either to reverse engineer something or research it. And I think other than eating it, that's what you would do if you bought a patented phone or whatnot. You would sell it or use it or take it apart. The difference is that for most patented, and those would all be examples of where the patent is exhausted. It's not going to prevent you from doing those things. The difference with the seed is you typically don't dig a hole in your backyard and put your phone in there and bury it and hope that it replicates itself. So this case really is about self-replicating technology, and so how does Monsanto protect that self-replicating technology? I kind of already outlined, but you buy the seed with a license that you get to plant it once. You plant it, that's a licensed use of the seed. The seed grows, it replicates, which is authorized by your license. You harvest it and you sell it to a grain elevator that then sells it to a food producer. But Baumann did not like this arrangement. He grew weary of having to go back to Monsanto every year to buy the patented seeds, so he came up with his own way of growing seeds. And so here I have an icon that represents maybe the public perception or maybe just Baumann's perception of Monsanto. But so you would have a first farmer that would, as the previous slide indicated, buy the seed, plant it, harvest it, sell it to a grain operator. The grain operator would then typically sell it to someone who's going to make food out of it, but that's where Baumann came back and bought the seeds deceptively. Rather than making food with it, he planted them and saved some of them for replanting the next year, and he repeated that process 8 times before Monsanto caught on. Baumann put forth the argument that, hey, this is just patent exhaustion. There's precedent. When after the initial sale, it terminates all patent rights. Seeds are meant to be planted. What else are you going to do with it? His other defense was a blame the bean. I didn't reproduce anything. I just put it in the ground. It reproduced itself. The Supreme Court had its own precedent that exhaustion doctrine does not extend to making a new product. So this is where I think the case kind of diverges a little bit from patent exhaustion in the sense that a separate transaction happens once the bean starts growing in the ground. I would argue that the planting of the seed in the ground might be covered alone in the abstract under patent exhaustion, similarly to how if you did that to your cell phone, that would be protected by patent exhaustion. But the difference, obviously, is that the bean starts to self-replicate. And there, at that point, you can kind of think that the original sale of the first seed is destroyed, that transaction is over, and at that point, the farmer or the person that planted the seed in the ground is undertaking a new transaction of reproducing something that's patented. And because you can't separate the planting from the reproduction, it's all part of the same premeditated plan to get the beans to self-replicate. Therefore, you need a license to do it. So I guess the one other thing to note about the decision was that they specifically said they're limiting their decision to the facts of the case here, and they specifically pointed out self-replicating software where similar issues might arise if you install software on your computer. It necessarily replicates itself in order for you to actually be able to use the software. Looking at this case in the context of some of those questions I asked, I don't think this is a case where Monsanto is being evil or being overly aggressive. I mean, if they're not going to protect the people that are buying their seeds and growing seeds with it, their patents and their seeds become worthless their seeds will become worthless in no time. All right, we can move on to John Wiley & Sons, which is also exhaustion. And one other thing to note about the Monsanto thing and the analysis of it is I think that Bowman clearly takes himself out of the context of just being the poor farmer, consumer, where the big corporations coming after me, because he transforms himself into a competitor by generating seeds and cutting Monsanto out of the process. So I don't have sympathy for him. And that's kind of a similar fact pattern that happens here in the copyright exhaustion case, where you have a consumer that kind of transforms herself into a competitor. So if you don't know, Wiley is a publisher that sells textbooks. They have divisions all over the world. One of them is in Asia, one of them is in the US. In Asia, they make books, they sell books, and the consumers use the books in Asia. Meanwhile, they have a separate business unit, if you will, in the United States that's making books, that's selling books, and people are using books. And ideally, these worlds are kept separate. This kind of reminds me of that Seinfeld episode with the relationship George and the independent George. If the two worlds collide, bad things happen. And in Wiley's case, the bad thing that happens is the consumers in the US realize that consumers on the other side of the globe are buying the same book for much less. So the way they try to keep the two worlds separate is they have this scary disclaimer in the fine print that's located right next to the copyright notice, where they say it is illegal to import this book back into importing the book into another region from Asia is illegal. But as we'll see here quickly, that scary language has no teeth. So this is Kurtzang's way of circumventing Wiley & Sons' plan to keep the two worlds separate. I guess I look at it as he's trying to jailbreak the books from Asia, get them to the United States. The way this arises is that he's a student in New York. He has family in Thailand. He gets his family to buy the books in Thailand. They ship them to him in the United States. But he doesn't stop there. He's not simply using the textbooks for his own educational benefits. He's reportedly having so many shipped over that he's made several $100,000 doing that. So he, as I said, he's kind of transforms himself into a competitor. And so this case really boils down to a statutory interpretation. The opinion is quite lengthy and, quite frankly, is not that interesting. It's how do you synthesize the exclusive right of Section 106 with the first sale doctrine of Section 109 with the importation requirements of Section 602, which are directed to, the first sale doctrine is directed to works made lawfully under this title. And I think that this synthesis of this law might be something that would be up Scalia's alley. So in putting those three statutes together, the question boils down to, does the lawfully made under this title of the first sale doctrine modify the importation provision of the statute that references the exclusive right? There was some precedent on this case in Quality King where the Supreme Court said, yes, you could re-import that book into the United States, but they also said that was limited to the situation where the book was originally made in the United States the first time around, which I think more clearly implicated the lawfully made under this title provision of the first sale doctrine. So then the question becomes is if the book is initially made overseas, is it made lawfully under this title? Which is the question in this case. Wiley & Sons argued that you can't be lawfully made under this title if you're made not in the United States because the US copyright laws don't apply there. Kurtzsang, not surprisingly, took the opposite view where lawfully made under this title is just meant to generally say in accordance with or in compliance with, or I think the other way you can think of that is that it's not in violation of this title, that maybe the books in Asia weren't made in compliance with the US law, but they certainly weren't violating any part of the US law. So as I said, much of the length of the opinion is legislative history and statutory interpretation and constitutional objectives and legislative intent and all that. So in the end, they said, yes, it was legal for Kurtzsang to bring those books back into the United States. Looking at this with the questions that I presented about economics and consumers, it was interesting to note that in the opinion, they did talk at length about the practical considerations and the economic horribles that a lot of different industries would have to face, such as libraries and bookstores of that nature. So they did quite clearly implicate the broader political issue. So, okay, well the good news is that's the last of the cases I'm going to talk about in detail. So I do have slides for these other cases that I'm just going to quickly boil down to a condensed version here. So the Nike Already case was about trademark infringement. They own a trademark for the Nike Air Force One. Already is making the shoe called the Sugars, and Nike asserted that the Sugars were a trademark infringement. Just on a side note, I had a pair of these Air Force Ones a couple of years ago. I thought they were perfectly reasonable, comfortable shoes. They were all black. I thought they were perfect for khakis and jeans, but I got married and then I don't have the shoes anymore, so Okay, so this is kind of a jurisdiction case, so it involves proceedings. Nike sued Already for trademark infringement, Already counterclaimed for invalidity. Shortly thereafter, one might say rapidly thereafter, Nike filed a covenant not to sue, which they basically were backtracking from their original complaint. They sought to dismiss the trademark infringement and the counterclaims on the grounds that the case or controversy had been extinguished because there was no more federal jurisdiction. The covenant not to sue, the preamble of it starts by saying, Already's actions no longer infringe or dilute the Nike mark at a level sufficient to warrant the substantial time and expense of continued litigation. Now, I'm not sure what happened between the filing of the counterclaim and the filing of the lawsuit, but they backtracked in a hurry to say, whoops, we don't think you're infringing anymore. Already surprisingly wanted to keep going with the litigation, and the reason they put forth was that they have investors that want to put money up, but they want to get rid of the trademark before they shell out the money. I guess the covenant also covered all existing products or future products that are colorable imitations of the Sugars. Basically, the lower courts found in favor of Nike, saying that Sugar Already couldn't produce any evidence that they were going to infringe the trademark or had plans to infringe the trademark with any shoes that would not be covered by the covenant. The Supreme Court, the Supreme Court upheld the covenant not to compete after looking at jurisdiction law and the voluntary cessation doctrine. Those in and of themselves aren't that interesting. I think the two interesting things in the cases are that in order to keep the controversy alive and stay in court as they wanted to, already would have had to have admit that they were going to potentially infringe the trademark, which I wouldn't imagine too many people would want to do, given the fact that they're putting products out there. The other thing is that I find interesting is that Nike had to admit to wrongful behavior, and I found one commentator characterizing it as trademark bullying. I guess I wasn't that familiar with that term. I'm not sure how that squares with a patent troll, but it doesn't seem like something I'd want to be called. And I think the result of this case is kind of interesting from the standpoint is I don't know how often this type of situation is going to occur, but I think what it does give is it gives owners of trademark rights kind of a license to assert a trademark and kind of backtrack if they think it's not going in their favor. So I could see that would be something very useful going forward in an economy based around IP. The Gunn versus Minton involves patent malpractice, and this is essentially the patentee filed for a patent more than a year after he was entitled to file for the patent, got a patent, sued somebody, lost on infringement. His patent counsel didn't raise the experimental use doctrine because obviously they didn't think it was experimental use. So he tried to raise that raise that issue on appeal. They wouldn't let him raise it because he didn't raise it the first time around. They said he waived that right, so he lost on that in the appeals court. So he was obviously unhappy, sued his attorney in state court, arguing that the failure to raise the experimental use defense led to the invalidity. He lost that, appealed that, and then raised for the first time that because the underlying issue was related to patent law, that it should be a federal court issue. The Supreme Court of Texas eventually agreed and remanded the court to, or decided that it was a federal court issue. The Supreme Court, then the U.S. Supreme Court, analyzed the facts under this standard. Boiling it down, they said that although there was a federal issue that was substantial to the parties involved in that case, the facts were not substantial to the federal system as a whole. And the way that was interpreted is that even though the state court will have to interpret the substantive patent law, that analysis is backward-looking, it's fictional, that it will produce no precedent that will be binding on the other federal courts, and therefore the issue of the experimental use has no relevance to the federal system at large. And furthermore, they said that the interest of the state regulating the attorneys trumps that hypothetical backward-looking patent law analysis. So they basically said that it's a state law issue. And as I mentioned, there's two other cases still out there that we're going to see. I think the FTC versus Watson Pharmaceuticals has been, they've done oral arguments on that one, and that is a settlement agreement for generic pharmaceuticals, the so-called pay to delay, where the patent owner pays the generic company to stay out of the market for a certain time period, probably until the patent expires, and at which point they can compete on their own terms. So that one will be decided probably later this year. And then, as many of you probably heard, that they just granted cert on this Medtronic versus Boston Scientific case where, in the context of breaking a license agreement, whether or not the patentee must prove infringement or the licensee must prove non-infringement. So you'll probably hear about those next year at the Kinney and Lang seminar if you come. So that's all I have. I think, as I said, if you kind of look at these as a whole, maybe the things to consider are maybe more cases recently as opposed to 10 or 20 years ago implicate the rights of the individual as opposed to just being a competitor that maybe the consumer has to pay slightly higher prices if the competitor loses, but these cases are being seemingly more directed at individuals and at things that are more relevant to the consumer. As Austin was talking about with cell phones, these things are impacting more and more people on a day-to-day basis. And I think the other takeaway is that in looking at all these cases, it really stresses the importance of having a cohesive IP enforcement plan. You have to be thinking all the time, ahead of time, particularly before you file a lawsuit, of who are you going to license, who are you going to sue, how long are you going to keep it going, those types of things. So a lot of ground there, and it looks like I only went 2 minutes long, so thanks for paying attention.